we have a mixture of different legal institutions to cope with the accident problem. That is insurance, that can be no fault insurance, as in New Zealand. It can be tort liability, it can be regulation of safety, and the mixture is different from country to country, and it varies from country to country, and it varies also with the development of a country. So a rich country might have a different mixture of these different institutions than a poor country. Now, in what time is now left, I want to go a little bit deeper into liability, into tort liability. And what I want to present here is the theory of negligence, the economic theory of negligence. Now, in tort, for a tort claim to be to go through in court, usually the most widely used norm is the negligence norm. That is, if there's a victim and a tortfeasor, and the tortfeasor causes a harm to the victim, this does not mean necessarily that the victim has a damage claim. So if the tortfeasor was not negligent and still caused the accident, then the damage falls on the victim. Only if the tortfeasor was negligent, he has to pay damage compensation. That is what we mean when we talk about the negligence system. And I want to go a bit deeper in into this negligence. And the question we ask here is whether negligence is a rule which leads to efficient deterrence. In other words, whether negligence is a rule which leads the tortfeasor, if he is not judgment-proof, if he is fully motivated, if all these problems which we have discussed before do not exist, if the tortfeasor can and will pay the damage, and if every victim goes to court and so on. Now we assume this. Whether then negligence leads to efficient deterrence. Now, to understand this better, we have this graph here. Now, we have here at the x-axis, x are the costs of care to avoid an accident. So you can think of the cost of care as the units of care, or the levels of care, the level of care multiplied with the cost per unit of care. Now I give you an example which is for the Indians is very far-fetched, but I give it anyway because it illustrates. Now I live in a city in which the municipality in winter times, when it is icy and snowy, like in India, then in winter times, when under these conditions, the municipality has a duty to keep the roads clear, to clear it from ice and snow, and if it cannot clear it from ice and snow, it must put salt on the streets so that it melts away and so on. So that is the way they make the city. They make the city safe in winter times, and they have a legal obligation to do it. Now when you look at what that costs, then you can calculate this in the following way. You can say, well, let's assume there is one lorry with, let's say, with sand or with salt, and there's a driver, and there are 3 workers who spread around the salt and the sand and so on, and clear the roads. Then to have this for one day costs so and so much money. And if you have 2 such trucks, then it costs double that much. And if you have 3 times as much, and so on. And therefore, here, when you have here the cost of care, then you can mirror them and have here also the cost of care. You see? These are the cost of care as a function of the cost of care. And this is then a 45-degree line here. Okay. Now the damages. Look at the damages. Here, these are the damages. If the cost of care are 0 here, then the damages are very high, right? And the damages fall, they are reduced with the level of care. So the more care we have, the lower are the damages here, the expected damages. Now what this curve tells us here are 2 things. First of all, with more care, the damages go down. So you can say that the mathematicians would say, the first derivative of the damage function is negative. But the curve also displays another feature. With more cost of care, the damages go down, but less than proportionate. So if you use now these trucks in the Hamburg streets, the first truck is perhaps needed to clear, the big roads, the highways, and so on. And the second truck is also to use the highways, and the third is to clear the roads, the first-class roads with much traffic, the big avenues and so on. And the fourth also, and the fifth. And the more trucks you use, then always the costs will increase proportionately, but the damages go down less than proportionately. See what I mean? And this feature, that with increasing cost of care, the damages are reduced, but always with a diminishing effect. That is a general feature, which this is only illustrated it by way of an example. You can take another example which perhaps fits more to the Indian situation. Now, assume you have a car, and the question is, no, you are a car producer, and the car producer has to answer himself the following question, and also the government agency which licenses this new car that it says it is safe enough, has to ask such a question: how many seat belts should be installed in the car? So you could say, when the seat belts were invented first in Germany, we had only one seat belt in the car for the driver. And the rationale given for that was that in 70% of all car drives, there's only one person sitting in the car. So if you install a second seat belt, the second seat belt is as expensive as the first seat belt, but the effect of the second seatbelt is smaller, because only in 30% of all cases there are 2 or more persons sitting in the car. Then you ask, what about the people sitting in the back? But the people sitting in the back, there are 2 considerations to be made here for the optimal safety. First of all, they are not so much exposed to the danger in case of a frontal accident, but still they are much better protected if they have also a seatbelt. But only in 10% of all cases, anybody is sitting in the back. At least in India it might be different because for various reasons. But in Germany that is the situation. So we had first, when the seatbelt was invented, we had 1 seatbelt in the car, in a new car, but after some years they added a second seatbelt, and now we have seatbelts for everybody in the car. But it is clear that let's say the 4th seatbelt or the 5th seatbelt in the car has the same cost as the first, but its effect is much less. You see? And then the question is, what is the efficient number of seatbelts here? And so this is another example, and you can make whatever kind of examples. For instance, again, take the car. When the first cars were on the market in the even before the First World War, we had the first car. But these cars, they were really death machines, because they had glass, normal window glass. So if it broke, then you know what that means, and how your face looked like if you had a car accident. That was later replaced by this special glass, which in case of an accident crumbles, into small pieces, which do not injure, but which cause no injuries. That was, of course, costly. Had to be a cost that was already done in the 1920s. But then, up to the 1950s, the cars, you had the steering wheel, and the steering wheel was, until the late 1950s, it was like a spare, it was fixed on a spare. So if you had a frontal attack, the steering wheel would go through your breast, would kill you like a spare. It was a spare directly on your breast. And then later on, they introduced a breaking point, so that whenever there is a frontal accident, then it breaks immediately, and cannot violate. Then another thing was then that the car, when it was hit from the sides, for instance, somebody hit you from the side, then it would badly damage you. Because this steel in the car is only very thin. So if somebody hits you from the side, then usually people were dead. So what to prevent this from happening? Now you have in the cars a solid construction. You are like in a cage, So if somebody hits you, if it is not a 50 tons truck, then you are relatively safe still. You are like in a cage, with very solid construction. And so that went on, and the car became safer and safer and safer. And of course, this had a real impact. In my country, I don't know how it is in India. For instance, in 1911, in the 1970s, we had the peak of fatal car accidents in Germany. And in West, I know only the figures from West Germany, because at the time we were not united. So we had almost 14,000 people killed every year in car accidents. And now with the united Germany, this number is down now to 3,500. And that is a consequence of making the cars safer. Of course, I would say the optimal safety level in a rich country is again higher than in a poor country. Would you agree? Now, you know, you have this new car, cheap car, which costs $2,000 or something. Pardon?
Nano.
The Nano, yeah, that was a big in the press and so on. But when I read this, $2,000, then I thought to myself, this is, I wouldn't buy that car personally, because $2,000 is less than half of the safety investment into the car which I own. You know, in my car, there are roughly the safety investments and all these things which I talked about are about $5,000. And then if you have a car of $2,000, then you can ask how much safety investment is there.
No.
And I think there is that is normal, that if people have low income, then of course they buy less safety. For instance, here it is quite usual that the whole family sits on a scooter, right? That is also not very safe. So people take a little more risk. So, but coming back to this year, total costs and total the damages are a function of the costs. So, now this graph here abstracts from the tertiary costs. So we assume them away. There are no tertiary costs. And if there are no tertiary costs, then what we want to minimize, or what we want to achieve here, is to minimize the sum total of accident costs and damage prevention costs, right? So you have here the primary cost of accident, the damages, and you have here the cost of care. And you want to minimize the sum total of that. That is, you must laterally add this amount and this amount, and then you get a point on this curve. This curve here is the total cost curve, consisting of accident costs, the primary cost of accidents, plus the cost of abatement, the cost of care. And what you see here is that this curve here is what mathematicians call well-behaved, in the sense that there is an interior, it is a convex function, and there is an interior minimum of this function. So you have here one point at which these costs are minimized. And therefore you can, from here you can deduct here, this is the optimal level of care, and these are the damages which still arise at the optimal level of care, and that is the level which is efficient, which we want to achieve. See? Okay, now our next question is whether negligence, the negligence regime, will lead the tortfeasors to reach that efficient level of care or not. In other words, whether the law gives incentives to the members of the legal community to reach that level of care which we believe, from at least from an economic perspective, to be the one which we want to achieve. So, you had a question.
So economically saying, if I want to say that I want the level of safety in accordance with Germany, but according to economy also, so can I use the ratio of the cost spent on risk, total welfare cost divided by per person capita of Germany? It must be equal to that for India. Is this ratio workable?
The ratio of cost of abatement cost to per capita income?
Yes, sir.
It's a good question. I have not thought about this. Yeah, that could be. I think it could be, but it is not necessarily so. I have to think about that. I don't know. That depends on particular function, how the function, how the demand for safety increases with per capita income. If the demand increases linearly, I think then you are right, but if it is increasing more than linearly, then it is different. If it increases less than linearly, it is also different. So it depends on the particular function. Now, now we have this graph here. Is a graph which is exactly the same as before, with some slight variations. So you have here the x asterisk is the optimal cost of care. And now the court comes into play. The negligence means the following. Negligence means that the court, usually the Supreme Court, fixes a level of care which it calls the due level of care, and then asks whether a particular tortfeasor, when they have a tort case, whether the tortfeasor has reached the due level of care, and or a higher level, and if so, if the level of care is reached, if the due level of care is reached, then the tortfeasor has not to pay damage compensation. If it is below the due level of care, he has to pay damage compensation. See what I mean? Now, we assume now, for convenience, that is not a necessary assumption, that the due level of care which the courts fix is equal to the efficient level of care. For whatever reason, it can be that the courts all have studied economics, which is not the case, the judges, or for whatever reason, or that their intuition tells them that the efficient result is also a desirable result, or whatever. So we assume here that the due level of care is equal to the efficient level of care. Now, this has the following consequence. Whenever the actually observed level of care is in this range here, in this interval, the tortfeasor was negligent and must pay. If it is, however, in this range here, then the victim must suffer the damages and gets no compensation. So that is, whenever the tortfeasor has reached this a level of care which is equal or higher to the due level of care, the damage falls on the victim. And if the level of care is in this range, then it falls on the tortfeasor. Then the tortfeasor has to pay damage compensation. Now, this has the following consequences. Now, from an individual point of view, from the point of view of the tortfeasor knows when he plans his this here, then the tortfeasor knows that he will be liable in case of an accident. And therefore he knows that in that case, if he allocates less than the due level of care, his costs will be the sum total of his cost of care and his and the damages. So we assume here, but for convenience, that always all damages are paid, and that there is no, no rational apathy or no judgment proof problem and so on. These problems are here all ruled out in the standard model. And then this red line tells us that these are the costs for the tortfeasor when he does not reach the due level of care. As soon as he reaches the due level of care, then he does not pay damage compensation, and his only costs are the cost of care. So there is an abrupt change here in that direction, and then when he goes further into this direction, then his costs of care increase. And now we can easily see that he minimizes his total cost, he minimizes his costs when he reaches the due level and the efficient level of care. So this leads us now to an important research result, namely that if the courts fix a due level of care which is equal to the efficient level of care, then negligence leads the tortfeasor to reach the efficient level of care and the due level of care. Right? So we can then say that under these conditions here, the negligence rule leads to the allocation of efficient care, of an efficient amount of care. Got the point? Now we change our assumption a little bit. This is again the same graph as before, and this time, however, the due level of care is lower than the efficient level of care. What happens then? Then the tortfeasor knows that if he is in this range, he is negligent, but if he is in this range, he is not negligent. Therefore, he pays the total cost only as long as he is negligent, and then there is a jump as soon as he reaches the due level of care, and he reaches the due level of care, and then if he increases, then these are his costs. And again, this is here the cost minimum which he can achieve, and he reaches the due level of care, but not the efficient level of care. So we can say that is our second result. If courts fix a due level of care which is lower than the efficient level of care, then the tortfeasor gets an incentive to reach the due level of care, but not the efficient level of care. Okay. Now we change this again a little bit, and now we assume that the tortfeasor reaches a due level of care. No, that the courts fix a due level of care which is higher than the efficient level of care. Let's say this one. Then the tortfeasor knows that in this range here, he is negligent. And then these are his costs here. And then it goes down, and again like this. So in this presentation here, the tortfeasor has an incentive to reach the due level of care, and therefore it overstretches the, from an economic point of view, his care. But this is not the only result. Now assume that the courts fix a very high level of care as the due level of care. Let's say this here, so I have not depicted this here, but assume we have this is the due level of care, xd2. Then we go up here, and then what we see, the cost of care here, to reach the due level of care, they are here so high that they are higher than reaching the efficient level of care and paying damage compensation. You see, if you compare this point here, that these are the total costs, and if you see this point here, then these are the total costs, because it does not pay damage compensation, but the cost of care are so high that it is better for the tortfeasor, for profit maximizing tortfeasor, to go into that direction and pay damage compensation. So what we can say now is that if courts fix a due level of care which is much higher, if they much overstretch the level of care, then the tortfeasor has an incentive to reach the efficient level of care, even though he pays damage compensation, because the sum total of damage compensation and cost of care are lower than the due level of care, than the cost of reaching the due level of care. Yes?
Why would the tortfeasor incur any cost of avoidance? Why would he not take any care at all? I mean, if he knows that the cost of care is so high that he might as well not incur it, why will he even go till X star or whatever? Why will he not remain at 0?
Yeah, you see, assume that these are his costs here, right? Then if he saves on these costs, then he is at this point, and then the damages are so high, you see, then he has to pay for the damages.
Right, but so why would damages follow this curve? I mean, it's probably a silly question, but in an accident, would the damage not remain constant even if care was taken or care was not taken? I mean, for say like a road accident, we could say that care is taken when a car has anti-skid brakes, and despite and probably law requires a car not just to have anti-skid brakes but also to have some sort of a automatic speed reduction system. And so basically what I'm saying is that the efficient level is just to have anti-skid brakes, and the due level is to have anti-skid plus some sort of a systematic speed reduction. Now the tortfeasor has the option not to put both systems in his car, because when an accident happens, the damage to the victim will remain the same irrespective of whether there was one system or there were two systems.
Well, I have not quite got this. What you say, your question was, why is the tortfeasor not allocating no care at all?
Yes.
But then he pays the damage compensation for the highest possible damage. With no damage, with no care, the damage are extremely high.
Number of damages will increase.
Pardon?
Number of accident will increase if there is no safety system.
Yeah, if there is no care at all, the accidents will increase.
Yes.
You know, that is this curve here. This is the accident curve. You know, at this level here we have these very small accident, but with no care we have these. We have somewhere here, you know, very high accident. You see? So now what you can say is that negligence leads to efficient level of care under certain conditions. Not always, but under certain conditions, and especially these conditions are met either if the courts fix a due level of care which is equal to the efficient level of care, or if they fix a level of care which is very, very high. Then also it leads to efficiency. Pure economic loss and loss in the marketplace. Can any one of you explain to me what a pure economic loss is? Well, usually when we have a tort case, then a damage means that something is destroyed or hampered, your health is destroyed, or a machine is destroyed, or a house is destroyed, and so on. So something is physically affected somehow. Now assume, for instance, that a house burns down, and the house is worth, let's say, 50 million rupees. So then the victim has a loss of 50 million rupees, right? But the capital stock of the society, the wealth of the society, is also diminished by 50 million rupees. So there is no difference between the individual loss and the loss of the society at large. It is exactly the same, right? This is, however, not the case with so-called pure economic losses. I give you some examples of pure economic loss. When the loss is not directly correlated with a destruction of a resource. Now assume the following case. There is a famous football player becomes the victim of an accident. Then this is of course not a pure financial loss, so he can recover all the losses he has. But assume that this, was the player with a hot leg or whatever it's called. He was the star in the team, and because he is now cannot play, that leads to losses for
his team.
Pardon?
For his team.
Yeah, not for his team, but for the football club. The company which runs this club makes losses because there are less TV income and less whatever, less fans are coming, and they make a loss. That is a pure economic loss. And this loss is usually or often not covered by civil liability. So the club in Germany, for instance, this club, if he claims damage compensation, and even if the club can prove for sure that, that the damage is so and so high, if it is not just pretends that, but can give clear facts about this, they cannot claim damage compensation. Or take another case. Take the case of an oil spill. There is an oil spill in a tourist area, and this oil affects the beaches, and they have to be cleaned up, the beaches, which is very costly, and but it also affects the fish swarms. Assume there are fish swarms and these fish swarms are gone, which leads to a loss for the for fishermen. They have no income. This is a pure economic loss. And now assume that there are hotels, and of course the hotels, they are unaffected by, if they were affected it is a different thing, but they are totally unaffected by the oil spill. But the customers are not coming because they want to go to the beach, and the beach is full of oil. And therefore nobody goes to the hotels. This is a pure economic loss. And such economic losses are often not covered. And a particularly important aspect of pure economic loss is the following. Assume that you have a stock listed company, and the auditor gives a wrong audit. There is a company, referred to a German case some years ago. A company had bought a construction company, but they also owned houses. They built houses and owned houses. And they had bought huge amount of real estate in East Germany after the reunification of Germany, and they paid high prices for it. There was a boom, and then came a bust, and the prices collapsed in the end of the 1990s. So what the values they had in the book were 5 billion Deutschmarks, 2.5 billion euros, but the real actual value of these real estate was only half. And if they had written off this to the realistic value, then the company would have to file for bankruptcy, because all the equity capital would be gone then. And if the equity capital is gone, a company has to file for bankruptcy. I think that is not different in India, is it?
Same. It is the same.
It's the same, okay. So the management, however, wanted to conceal this. They said, oh, perhaps it goes up again and so on. So they manipulated the whole thing, and they even, they hired some experts who gave an expertise saying that, that this land is worth more. So they wrote a balance sheet in which the value of this real estate was 5 billion, and then the company was not bankrupt. And also the management was very positive, when they about their businesses, and the price of the shares was about 120. And of course, for these stock-listed companies, the management cannot just publish the balance sheet, but it must be audited by an auditing firm. And the auditing firms, they get a lot of money for this. So, for instance, an audit for a bank, for a stock-listed bank, costs about 2 million euros in Germany. So it's really a significant amount of money. They get a lot of money for that. Now this auditing firm, of course, it was the duty of the auditing firm to check whether the balance, the different positions in the balance sheet were realistically valued. that the assets were not overvalued, for instance, which then blows up the equity capital on the other side of the balance sheet. And they did not, they just looked what the management had done, and they trusted then on these things. They could have sent one of their employees to East Germany, talk with some real estate brokers, or even make some telephone calls, whether that is realistic or something. So it would not have been, so expensive, but they didn't do it. So they signed, okay, everything okay. So what happened now was that when the balance sheet was published, the company was actually bankrupt, but nobody knew it except the management, which concealed it from the public. And then the price remained at 120 all the time. But then after some time, this bad news reached the stock exchange by some other channels of information. And when that happened, the stock prices went down within seconds. I have the chart, I don't have it here, but within seconds, the stock price dropped from 120 to 20. So the owners of these shares lost within seconds 80% of the value, more than 80% of the value. Now the question is the auditor liable for these damages? Should the auditor be liable for these damages? And again, we have this problem that this is a pure economic loss. It is, nothing has been destroyed by this. No life lost, no safety lost, no resource destroyed, no house burned down, nothing. And the question is whether this reluctance of legal orders to compensate for pure economic losses has some rationale in economics. Now the first author who dealt with this problem was an English lawyer, Bishop was his name, and he didn't get it right, I have to say. I have myself published on this together with an Italian, but many other people like Goldberg from New York, from the Columbia University is a great name. Richard Posner has published on that, and so on. But the right starting point of Bishop was right. He said the difference between pure economic loss and other losses is that when it comes to pure economic losses, we often have a divergence between private losses and social losses. In pure economic loss, the private losses of the affected are often much higher than the social loss. Now I want to illustrate this to you with a graph. So, this is the normal picture. We have an omission or act of the tortfeasor which leads to a loss, and this loss is a private loss, but the private loss is identical to the social, to the loss for the society. Now, when it comes to that means, I'm sorry that I copied this out of another slide for my students in Hamburg. That means handeln oder unterlassen, means an act or an omission. So here we have an act or an omission, and the same act might lead to gains for a group of people and to losses of another group of people. Now assume that the losses are 100 and the gains are 80. Then the social loss would be only 20, right? And now if we compensate for these losses, for the 100, then we give incentives to the tortfeasor to avoid losses of 100, but the real losses for the society are only 20. So from a societal point of view, we get an overcompensation and over-deterrence. So the level of care becomes too high, or might become too high. That is the problem. And therefore Bishop says we should not compensate at all, then we get under-deterrence, but under-deterrence is better than over-deterrence. So I don't know why. But others say, for instance, there is a very well-known law and economics professor, Gilead Israel from the University of Jerusalem. He says, well, the courts should try to calculate these losses of the affected, but also to calculate the gains of other people, and then compensate only the difference. The compensation should not be full compensation, but only that compensation which is equal to the social loss, and then we get the right incentives. See what I mean? Now we can relate this to this accounting case, which I just told you. And that illustrates it. Now, here we have the timeline. And this is the share price for the company. And this is the share price here. Now, this here is the time, the point of time here, when the balance sheet is published to the public, and the public gets the wrong information. If the public would have been given the right information at this point of time here, then at this point of time, the shares would, the share prices would have dropped to this level, right? But now the share prices remain high and they drop at this level. Now it is assumed now that it is totally out of question that the accountant was actually negligent, that he has negligently wrongly signed the balance sheet, and that therefore the company went too late into bankruptcy. Now the question is, should all shareholders receive this here as a damage compensation? No, why not?
Because shareholders had to take this loss. I mean, the company that they have invested in has not been managed well. It's suffered losses. So, I mean, who else apart from the shareholders has to absorb the losses here? I don't think it's sufficient to compensate them for the choice of share purchase that they've made here, because it's just a badly managed company. Someone has to foot the bill.
Yes, you know, I agree, I have couple of years written an article, especially on this case, and that was, I give you the way how I argued here. Now, assume that the accountant would not have made this mistake. Then what would have happened? The share prices would have dropped at this point of time, right? Therefore, what you can say at first is that all those shareholders who bought the shares before this point of time and held them for the long run made no losses.
Yes.
Because without the negligence of the bookkeeper, they would have made the loss at this point of time. Now they made the loss a little later.
Right.
So the total loss is exactly the same and they made no loss at all. Would you agree with that?
Slight deviation.
Pardon?
Actually, because there is always a cost of interest of money. Factor cost of money.
Okay,
But
yes.
that can be neglected.
Yeah, that's right, yes. But that's discounted. It's just only, it's not 20 years here, it's a matter of a couple of months, So that I have discarded here to keep it simpler. Now assume that there is a shareholder who bought the shares at this point of time and sold them at this point of time. Has he made a loss? Has he made a loss? No. He made a gain, because if the accountant had been not negligent, then he would make at this point of time this loss, and now he buys here, he sells here, he makes a huge gain as a consequence of the negligence of the accountant. Now assume that somebody buys here at this point of time, that somebody buys here and sells here. He made a real loss, because if the bookkeeper had been, the accountant had been non-negligent, then he would have bought this at a much lower price, if he had bought at all. So he is really affected. But his gains are exactly equal to his losses are equal to those who bought here and who sold here. So the net loss is zero. Then you have a fourth group, some people who bought here and sold here, within this range. And they made no gain and no losses. So the question is now, if we would assume we would give all shareholders, we would give all shareholders a claim against the accountant, then it is absolutely clear that the accountant pays for damages which he had never caused, because all those who invested for the long run were not affected by the accountant. If you give only those here a claim, those who bought here and sold here, then this leads to full compensation of the affected. But those who bought here and sold here have a huge gain. So the social gain is much lower than the private gain, and you would again give too much incentives to the accountant. So you would give incentives to overstretch. I'm not telling anything here in defense of these accountants who often even have collaborated with companies and so on. This is all very bad. But you see here, this is one of the rationales why we should be careful with the compensation of pure economic loss. And what we find in the literature, what the literature basically says is that whenever a resource is hampered or destroyed, then no matter whether it's pure economic loss or not, we should compensate, and otherwise not. So, for instance, take this example of the fish swarms when you have an oil spill. Then here the legal problem is this: who owns the fish swarms? They have no owner.
Commons.
Pardon?
Commons.
No, they are not even commons. They are free access. They assume that this was in the
High seas.
in the high sea. Then they have no owner at all. So nobody can claim an ownership right, but assume that all these fishes were killed. Then if you now do not give anyone a damage compensation, then you would leave these fish swarms legally totally unprotected. See what I mean? Therefore, it is from an economic perspective advisable in this case to give full compensation to the fishermen, even though they are not the owners. This was, by the way, done with the Alaska oil, with the big Alaska oil spill of the Amoco Cadiz, this this ship, which caused one of the biggest oil spill in Alaska for vaccine for cattle. That was in a cattle area, and one of the bacteria or viruses, found its way out of the institute, and that caused a disease among the cattle, and all the cattle had to be slaughtered and burned. They could not be used, and of course that has had all to be covered. This is not a pure economic loss. But then there was a cattle auctioneer who had no income for a couple of weeks or months until the new cattle was old enough, and he had no income. Should he get compensation? Yes, because he cannot. That is a real loss for him, and there is no gain on any other side. But there are then other cases in which the same act which leads, the same negligent act which leads to losses of one person and gains of another person, if we have such a situation, we must identify it, and if we would only compensate the affected, then we would, from a societal point of view, give too much incentive for we would give too much incentives, and which would lead to over deterrence and to a too high level, too costly level of care. And these problems, these last problems, they are now very prominent problems in tort law. That is why I still edit them. For instance, in all these cases with Volkswagen and so on, Mercedes, and in many companies where you have manager's liability, auditor's liability, and so on, we are now in the process of sharpening this liability, which is absolutely necessary. I think, but we have to be very careful also. So there is, for instance, Volkswagen caused huge damages in the United States and has to pay for it, $15 billion, which is a good thing. But now also they filed, in Germany, they filed a case against Volkswagen company and want, I think, 4.6 billion euros damage compensation because the management of Volkswagen has informed the public too late about the exact size of the problem. And there we have a similar problem with this. And there, notwithstanding that liability might be necessary to some extent, this can easily lead to over compensation and overprotection. Well, that is the end. I'm at the end now of my course, and I hope that it has been of some interest for you, perhaps giving you some food for thought. And for me, it was great fun. I think you were really a great group because it was alive. We had always lively discussions, and that is what I like, and that is really made this course also for me a very positive experience. But we still have some discussion now.